All right, good afternoon. We will call the General Law Subcommittee, Subcommittee number 1 to order. Would the clerk please take the roll? Okay. Please close the roll. All right, we have a quorum. So first on the agenda, we do have a number of bills at the request of the patrons that those go by for the day. And those are House Bill 1491, House Bill 1748, House Bill 1765, No, and we do have an additional House Bill 1813, but there are a number of people here to testify on that bill. So what I'd like to do first is just take those first bills that I mentioned in a block. Do we have a motion to take those by for the day?
So moved.
Okay, we have a motion and a second.
Second.
We have a motion and a second. All in favor say aye.
Aye.
All opposed? Okay. All right. First, we have Delegate Wilt, House Bill 2133.
Thank you, Mr. Chairman and committee members. Before you is House Bill 2133. It clarifies that the state fire marshal or his designee is the authority having jurisdiction over state-owned buildings, properties, or structures for purposes of fire safety and fire prevention in accordance with the Virginia Statewide Fire Prevention Code. Mr. Chairman, that's the bill.
Okay. Thank you, Delegate Wilt. Before we take any comments from the public, do we have any questions from the committee members? Okay. No questions from the committee members. Is there anyone here in person who would like to speak in favor of the bill? Anyone here to speak opposed to the bill? Okay, and I do not believe we have anyone signed up online to speak, so I'll entertain a motion.
Move to report.
Second.
Okay, we have a motion and a second. Please vote. Okay, please close. Oh, okay. All right. All right. The bill passes 7-0.
I vote yes.
Yes, correct. We've got you recorded as
Thank you,
yes.
Mr. Chairman, committee members.
All right. Thank you. Okay. Delegate Davis, House Bill 1810.
Yes, sir, Mr. Chairman. Mr. Chairman, House Bill 1810 may look familiar. It's a free speech bill. It passed off the floor of the House of Delegates with the help of Delegate Adams last year almost unanimously, passed out of the Senate almost unanimously, subsequently ran into a minor problem. So it's back this year with a small amendment, but basically what this bill does is it says that any employee of the Commonwealth shall not be penalized by their employer for expressing their opinions on rules or positions during public meetings, during public comment periods, and gives that same protection to local employees at the local level as well. The only change that we made from last year is we excluded when it came to expressing the opinions inside of with a General Assembly meeting or state corporation meeting, but that's the bill.
Okay, thank you, Delegate Davis. Do we have any questions from the committee? Okay. Delegate Adams.
Thank you, Mr. Chair. So the way that I read this bill, so tell me if I'm wrong, that it removes protections if state employees are speaking in a personal capacity as a member of the, in front of the General Assembly as a member of the public in a personal capacity. Is that correct?
So I wouldn't say it removes it. It holds it to status quo. So in the status quo, any employee of the Commonwealth can be penalized for making comments during, or I can't say can be, but they have been penalized for making comments in public hearings, whether it be here, State Corporation Commission, local governing bodies, that sort of thing. This says that no one can be penalized, but it does not extend that protection to state employees when speaking in front of the General Assembly committees or state corporations. So I wouldn't say it removes the protection, because that protection doesn't exist today except by First Amendment rights. It just doesn't extend the protection in this bill to them implicitly.
Okay, any further questions? All right, anyone in person to speak in favor of the bill?
Yeah, Mr. Chairman, members of the subcommittee, Todd Gacky on behalf of the Family Foundation, and we support the bill. As we've seen in some local governments where there's been unfortunate situations where people have lost their positions because of speaking in a private capacity at the meetings. We want to just make sure that there are provisions in place that would provide protections for them going forward. So we support this bill. Thank you.
Okay, thank you. Anyone here to speak against the bill? All right, I'll entertain a motion.
Second.
We have a motion to report with a second. Please vote. Please close the roll. Yeah, Delegate Adams.
Thank you, and Mr. Chair and Delegate Davis, and I appreciate the conversation we had last year. I think my concern remains that a private citizen can't be protected when having its most basic right of expression in front of the lawmakers of the state. And so, unfortunately, I'm going to have to vote against this, but I wanted to say why.
Sure. No, and I appreciate that, Mr. Chairman, just briefly. I don't necessarily disagree with you, Delegate Adams, but we're trying to extend all the protections. We got 99% there, so the protection that doesn't exist today for that small group still doesn't exist, but we didn't take anything from anyone, but I can appreciate your thoughts.
There comes Buddy.
Okay, thank you. We have a motion to report and a second. Please vote.
Thank you, sir. You're all doing a great job. Keep it up.
All right, the bill passes 4-3.
Thank you, Mr. Chairman.
Thank you, Delegate Davis. Mr. Chairman, would you like to assume the?
I reckon
Okay.
so. You're doing great. I mean, how many bills have we knocked out so far?
Yeah.
I don't want to mess up. I don't want to mess up a good thing.
Yeah.
Oh, here's Buddy.
Actually, I got a bill coming up too, I believe.
Yeah.
I think that's you right there, Buddy.
Oh, he took your agenda. Here, no, here we go. Let me mark what's finished.
All right, this is my bill. This is all my stuff here. I'm gonna.
Mark the ones that are done.
We might not have a lot left because a lot of them went by.
Yeah, I'll mark those. That is done. This is going to be PBD after testimony.
Okay, so we're gonna take it up.
Take it up and then pass it by. That was my understanding.
Okay. Let me find my stuff here.
And if you need to get that packet here.
Yeah. I think we're about right here, so let's see here. Put this up here. Okay, now which one do we want to do here? March here? Let's see.
Yeah.
Delegate Converse Fowler, welcome. I apologize for being a little slow on the uptake here, but I was.
That's okay, Mr. Chair, thank you.
Thank you.
Mr. Chair, committee members, HB 1498 is a bill that I had brought up in 2019. It was left in committee. And this bill is really simple. It just makes an exemption for persons who whose activities are confined solely to removing unwanted hair by the use of strand thread. Now, this is you guys might have, noticed my wonderful eyebrows. The last 5 years I've been here, they're pretty great. But the way that happens is through a threading process. It's a process that happens usually in Asian communities. Thread is used to shape your eyebrow and remove the unwanted hair. Right now, it requires a full cosmetology license, where you would have to go to cosmetology school and get all the training. But just as in the law on lines, I think it's 28 and 29, 30 and 31, where you're just doing hair. You're doing blow drying, arranging, dressing, curling, or cleansing of human hair. Those things are exempt. And this is another thing that we're asking to be exempt, especially in the Asian American community. We find that this is a hindrance to small business owners to be able to open their business, because they have to get a full cosmetology license when they're not doing all the cosmetology things that would be involved with dyeing hair and the chemical process. So, Mr. Chair, I would like to entertain any questions, but just wanted to make sure I explained what it was right away.
Thank you, Delegate Commersfeld. Do any of the members have a question for the patron?
Yes, Mr. Chairman.
All right.
So let me make sure I understand this delegate. So you said that there was other means, blow drying and things like that don't require any licenses. Well, what businesses provide that? Because generally, I would think if you're going into a salon, whether you're doing your nails, your hair, and all that, that would kind of be under the same umbrella. So I'm not familiar with I've never had it, so okay. But wouldn't that be a concern for maybe some health issues there, or sanitation issues?
There have been no sanitation issues that have come to light at all with any of the cosmetology. The ones that are certified. There's one in a mall near in my city where they have their own not station. They have their own place in the mall that they do the threading, but they have to have the full cosmetology license. But all they do is threading. So they're all blowout bars. They're called blowout bars. We have one over by Town Center where I know Delegate Davis works, and they actually just do blowouts, which means they wash and dry your hair, and it's just a thing women do, to mostly women, to go and get their hair done, and that's all this simply is, except for it's to the eyebrows, and it's not to your hair, so not to the hair on your head. It's like waxing, but it's not waxing. There's no chemicals involved.
Okay, and thank you for your response, Delegate. So is there anybody here from the Department of Professional Occupation who would maybe enlighten us or have any concerns maybe with this?
I'm not sure.
I just see that the eyes and whatever the techniques are, that could be possibly a health risk. So if somebody could speak to that.
Good afternoon, Mr. Chairman. Mitch Pallas, Director of DPOR, and we do not have a position on this bill.
Okay, all right. Thank you, sir. No other questions, Mr. Chairman.
All right. Any other back from the crowd? Well, we have, I think, online here, Mrs. Megan Forbes. Are you there?
Yes, Mr. Chair, I'm here.
Good. Well, what have you got to say?
Thank you, Mr. Chair. Thank you for the opportunity. Mr. Chair, thank you for the opportunity to testify today. My name is Megan Forbes, and I'm an attorney at the Institute for Justice. We're a nonprofit public interest law firm that's based in Arlington. We work to protect civil liberties, including economic liberty, primarily through occupational licensing reform. And we support House Bill 1498 because it will remove licensing barriers for threaders in the state. Threading is a safe hair removal technique. It does not involve chemicals or dangerous devices. Threaders simply use their hands and a single piece of cotton thread to remove hairs. Right now, 20 states exempt threading without issue. A 600-hour esthetician's license is not needed to perform this service. And in fact, aesthetics programs rarely teach threading. And when they do, it's often not enough to provide instruction to where a person can take that skill and use it when they get out. Threading is a cultural practice. It comes from South Asia and the Middle East, and it's passed down from generation to generation between family and friends. Licensing threaders doesn't provide any more protection to consumers. It only creates barriers. We ask that you please support this bill so threaders in the state have every opportunity to thrive and grow their businesses. Thank you.
Thank you, Ms. Forbes. We appreciate your testimony. Thank you. Any other questions? All right, the chair will entertain a motion.
Second.
All right. Yep, open up the book. The bill fails to report by a vote of 3-5 or 5-3, however you look at it.
Thank you, Mr. Chair.
AC.
Good evening, Mr. Chair. I have House Bill 2256. I'm going to give a little basic what it does, and then I'm going to ask Glenn Oder to come and explain the rest. He's the director of the FMA. So basically this provides for security cameras on the grounds of Fort Monroe. We've been having recent activities of the criminal nature, mostly vandalisms, things of that nature, and we think that this would really assist in that. And I'll bring up the director at this time.
Welcome.
Well, it's good to be here. Could we go back to Chairman Warfield? Bill seemed to pass under him.
Yeah, welcome, former Delegate Oder.
Thank you very much, Mr. Chairman. Yes, this bill does two things, both of which we actually think might actually be in the legislation, but this removes any ambiguity and clarifies it. I'm going to start with the consumption fees. One of the challenges of Fort Monroe is we are legislatively mandated to be economically sustainable. That's a big challenge. We have 2 million square feet of buildings and very little income for those. And so one of the ways that we do this is with charging rent and so forth at buildings for utility fees and things like that. All of those are within our legislative act. Now what we're doing is we're signing deals that are 40, 50, 60, 70 years long, because these are developers who are going to be doing long-term leases at the Fort Monroe, and that allows them to actually use historic tax credits, which is going to make your buildings viable for redevelopment. There's very little value in those because there's so much work that needs to be done on the buildings. But yet, when the building is there, the building is also going to be benefiting from the common area maintenance at Fort Monroe. And so the opportunity now is to charge consumption fees on the retail and lodging components. And these are in the lease with the developer, so there's no hidden fees here. The best way to describe this would be like if you went to the Homestead or you go to some of the other historic sites. When you pay your bill, there's an extra added fee to it that provides for historic preservation, and it provides for the common area maintenance and so forth. And so what this bill does, it allows us to include that in our long-term leases with our developers. It's disclosed fully up front, and they would be agreeing to that, and it's a way for us to supplement the revenue at Fort Monroe when we do that. It is not going to be a big financial needle mover, but every little bit helps when we move forward. And the reason it's not a big mover is we don't have a lot of retail or lodging at Fort Monroe. The second thing is security cameras. Much as Delegate Cardoza said, we have a real issue with vandalism. I can tell you that one act of vandalism alone that we had was when somebody all night long stole copper gutter at Fort Monroe. It's not just the fact that they stole the copper gutter, it's that it is historic fabric that is irreplaceable. You can buy new copper gutter. We spent about $100,000 replacing that copper gutter, but it looks like it used to only newer, but it's not the historic fabric. And so we have an MOU with Hampton. They patrol the property. We also have a private security guard now who drives around the property. But working with the Hampton Police Department and quite frankly with other state agencies, they've said to us that cameras would be a very effective way to do this. And by inserting these cameras in special places where we have vandalism and crime, we actually will be tying those cameras in with the Hampton Police Department. So the Hampton Police Department will be observing those much like they do across the city of Hampton. The other thing that this bill does, it actually says that we will be monitoring those cameras according to state law, which is laws which have been passed in the past. So I'm here to answer any questions that you have. That's the essence of the bill, and we hope that you'll help Fort Monroe today with these bills. Let me know if you have any questions.
All right, thank you. Does any of the members have a question for the patron?
Mr. Chairman,
Anybody in the public like to opine on this great legislation?
Mr. Chairman, I move to report.
Okay. All right, you can open up the book. The bill reports 7-0.
Thank you.
Thank you. Let me see, I was looking around here.
Mr. Chairman, Delegate Carr.
Push the button. I voted.
Delegate Bolivar.
Good afternoon, Mr. Chairman.
Oh, she did?
Yeah, I had it written down.
There was going to have testimony.
Yeah, no, she's going.
That's what Ms. Morphy. Did you guys say March's bill was going to go by, but they were going to have testimony? But she's not here. So I don't know, he's thinking about it, he should just pass it by.
She came in the last meeting and told me she wanted to go by.
Well,
Delegate Boulevard.
All right, thank you very much, Mr. Chairman and members of the subcommittee. This is House Bill 1633. I'll give an overview. I'm hoping that I have my expert online who can go ahead and join us. But if not, it's relatively straightforward, and I think can go ahead and do the bill some justice. One of the strengths of our system here in Virginia of regulating contractors is the Virginia Contractor Transaction Recovery Fund. And for those of you who are familiar with that fund, it does help customers who have incurred losses, and I'm just taking this from the website for it, for losses through the improper or dishonest conduct of a licensed residential contractor. And so this is a fund that's not supported by taxes. It's actually supported entirely by assessments that are paid by licensed contractors. So under current code, in order to be able to access this fund, a person needs to have been awarded a judgment by a court of competent jurisdiction against the contractor. And so that's kind of the gateway. So you can't get to that fund unless you've gone to a court. The court decides in your favor, and you go ahead and bring that documentation back to the Transaction Recovery Fund. The issue that this bill is seeking to address is that actually a growing number of residential contractors are starting to use mandatory arbitration clauses in their contracts. And so rather than going to court, by contract, they must go to an arbitrator. And since a judgment from an arbitrator is different than a judgment from a court, that could actually interfere with a person's ability to access that fund. Mandatory arbitration has been around for a long time. Certainly not in a position to argue the pros and cons of mandatory arbitration, but it is starting to grow within the residential contracting community. And I think most people who go ahead and sign a contract aren't going to know that by having that mandatory arbitration clause in there that they're potentially and inadvertently locking themselves out of being able to access things like the recovery fund. And so that's what this bill does. It just solves for that problem and makes sure that a customer can be protected and access that fund, whether the judgment is through a court or whether it is through an arbiter. I will say that it's not a huge problem yet. This is kind of one of those rare opportunities where we have an opportunity to get ahead of the curve and just make sure that the Code of Virginia is clear in this regard. I'm happy to take any questions, Mr. Chairman.
Thank you, Delegate Bullivan. Does any of the members of the committee have a question for the patron?
Mr. Chair.
1 second. I think we have Mr. Let me see. Bozoff wants to provide some testimony, so please, we welcome your testimony, sir.
There he is.
Can you hear me now?
Yes, we just barely. Can you speak up a little louder there?
Certainly can. Is that better?
Yes, sir. Thank you.
Okay. Thank you, Mr. Chair, for the opportunity to speak on this proposed bill, and I would like to express my sincere appreciation to Delegate Bullivan for sponsoring it and being so very responsive to the concerns I raised. My name is Isaac Bozoff. I'm an attorney with a commercial litigation and business services practice in McLean, and I absolutely support the adoption of this bill. Most of my clients are business owners. Many of them are in the building industry, and occasionally I'm retained by an individual who has a dispute with a business. Usually it's a building contractor or a service provider in a related industry. Virginia actually has some exceptional consumer protection laws, as Delegate Bullivan mentioned. In particular, for instance, the Consumer Protection Act is a powerful litigation tool. And the Transaction Recovery Act, the Contractor Transaction Recovery Act, provides a means for consumers to get compensation when they've actually sued a contractor and won, and then that contractor has no assets, or they declare bankruptcy, or they just disappear. And the contractor fund is fully funded by contractor licensing fees, similar to other professions, such as the Virginia Bar's Client Protection Fund. What originally raised this issue was that last year I was retained by an individual who contracted with a pool company to build a pool, and the cost of the work was significant. And a dispute arose, and the client canceled the agreement within the stated cancellation period before the contractor had done any work, and the contractor refused to return the deposit. I reviewed the contract, and it had a mandatory arbitration clause, and that prohibited my client from going to court. And it completely excluded recovery of court costs or attorney's fees if the matter did end up in court somehow. I was asked by my client about getting compensation from the Contractor Recovery Fund. They had done their own homework. I explained the requirements for the fund, and in the course of that realized that if they would be ineligible because of the Act's requirement, the current Act's requirement that a claimant must first obtain a judgment in a court of competent jurisdiction in the Commonwealth. So in other words, a mandatory arbitration clause in a contractor agreement completely bars a consumer from accessing the fund due to the requirement that they must first obtain a judgment in a court. So it might also be argued that the mandatory arbitration could also make it hard, if not impossible, for them to access the Consumer Protection Act, but that's for another bill. In its biennial report for 2020 through 2022, DPOR states that it paid $1.6 million for the 2 years, constituting 104 claims. Each of those claims had to go through court, obtain a judgment, and then seek collection against the contractor and demonstrate that they had attempted to collect and weren't able to. On that same page in the report, it specifically states that a consumer must obtain a judgment against a licensed contractor from a court. Every single contractor's contract that requires mandatory arbitration is another consumer who, under the current code, cannot access the recovery fund. And as you all likely know, and as Delegate Bullivan mentioned, mandatory arbitration clauses are becoming much more common. The proposed bill remedies this by specifically including awards from arbitration.
Excuse me, Mr. Bozoff, could you sum up, please?
Yes, sir. I was actually on my last sentence. This bill remedies that by making it equivalent to a judgment in court, and I urge the committee to support this bill. Thank you very much.
Thank you for your testimony. Thank you. Delegate Bullivan.
I think Mr. Bozoff summed it up extraordinarily well, and just really appreciate the subcommittee's consideration.
All right. The chair will entertain a motion.
Mr. Chairman, I move to report.
Second.
All right. The matter is before us. Mr. Clark, all right. All right, on the bill, reports 8-0. Close the roll.
Mr. Chair, I
Thank you.
really appreciate your time. Thank you.
All right, let me see here. We got left here, Robert. Delegate Williams? Yeah.
Thank you, Mr. Chair. I do have an amendment to the bill that was introduced.
Okay, Ashley?
Mr. Chairman, we're posting that online right now for your review.
All right. Did everybody have an opportunity to look at the amendments? Do you have a motion to adopt the amendments?
So moved.
Second.
All those in favor? All those in favor?
Aye.
All right, the bill as amended is before us.
Thank you, Mr.
Delegate
Chair.
Williams.
So this bill started out with the idea that we'd like to be able to use active load stabilization mechanisms. And so this has to deal with cranes and loads that are traditionally stabilized through passive means, such as putting a tag line on it and holding it and on the ground, and eventually that tag line leaves the hands of the rigger and it heads on up. This is actually providing for an active load stabilization that utilizes technology such as gyroscopes and everything like a drone, but hanging heavy loads from it. The idea is this is advanced technology that will help stabilize it, will help not allow it to twist around. This same type of technology is used in helicopter baskets. I don't know if anybody's seen hurricane videos where the basket is just going like this, and you're like, that must feel terrible. So this would allow that to be used here in the Commonwealth. This bill began as sort of a direction, but through conversations with different stakeholders, including Bosch, we have amended it to ask Bosch to please write regulations on these two various types of equipment. To write the regs and so that these new pieces of technology can be used here in the Commonwealth. I have spoken to Bosch, and I know that they will likely speak on this. And online, well, I don't know what line you guys have, but in the second paragraph where it does talk about shall report by, I think you guys might have January 31st of 2024 right now. We're open to a friendly amendment if Bosch feels that they can't complete that. And I think we talked about a 2-year return. So if that happens in front of this committee, I would be amenable to that. I know there's people in the audience willing to speak in support, and I know that the Department of Labor is here as well.
All right. Thank you, Mr. Delegate Williams. Does any of the members have a question for the patron? Delegate Carr.
Thank you, Mr. Chairman. Thank you, Delegate Williams. Is this written so that it can be just concerning one company that provides this, or this will be a kind of a universal across the board for any company that provides this kind of service?
Yeah, it's going to be very
uses technology.
It's going to be very generic. We try to write it broadly, and we also wanted to make sure that it remained permissive. You can use the simpler technology, the older technology, if you're using it on simpler systems, construction sites. If you want to go on way up high and use this technology, it's going to be available to you. There's multiple companies out there that use this type of technology, so it would not say only one type of company could do that. As long as it's categorized, which we try to define active load stabilization, as you see there, computerized control and human input. So with this technology, they actually stand not below it, but near it to watch the loads go up, and they can control it a lot like a drone with, like a remote control. But to your question, it would not pick one winner.
Okay. Delegate Runyon?
Thank you, Mr. Chair. And speaking about to the delegate, I appreciate we've had some conversations all week long, and I actually, in my business, we've operated cranes and the such before and with the old style technology. So I do want to applaud the delegate and those folks that are involved in this for bringing forward to have the discussion. So I'm very comfortable with it. It's permissive. I believe that it can improve safety but to make sure that we understand what we're doing is we're asking the Virginia Department of Labor through the Virginia Occupational Safety and Health folks to promulgate regulations as opposed to impose this system currently. And so it'll give the industry an opportunity to address any concerns that may appear that have not appeared yet. And so again, I applaud you for moving this thing forward well, Mr. Chairman. I would also offer a motion at the appropriate time.
Excuse me, Delegate Williams, you mentioned you might have some testimony from some folks.
That's right. If you just, whoever is in support of the bill, they're welcome to come on. That'd be great.
Yeah, that would be, anybody in support of the bill?
Me too. Yeah.
Right now. Yeah. Wait a minute. All right, and briefly, please.
I'll be as
Thank
brief
you.
as possible.
Thank you.
Thank you, Chairman
Please.
Fowler and committee members for having me today. My name is Angela Driscoll. I am the Director of State Government Relations for Vita Inclinata Technologies, a company that designs and manufactures intelligent load stabilizing systems for the construction and industrial crane operations, as well as military and civilian rescue aircrafts. I'm here to urge your support for House Bill 1392.
Okay.
The use of taglines in construction and industrial work sites is not only outdated, it's frankly dangerous, and these date back thousands of years to the building of the pyramids in Egypt. And even though safety-focused technology and solutions for crane operations have certainly evolved, the very regulations governing these have not.
Okay.
And by allowing the use of load stabilization technology, HB 1392 will help to continue to drive crane operation safety and innovation, but more importantly, it will provide companies with the value of choice to determine tools, technologies that will dramatically reduce or eliminate the risk of crane-related injury. So we urge you to support 1392.
Thank you for your testimony. Thank you. Yes, sir.
Thank you, Mr. Chairman. Chris McDonald on behalf of the Associated General Contractors. Just wanted to thank the delegate. He was really receptive to our concerns early on. I think this bill has become a bigger lift than he expected, and really are grateful for the work he put in. No longer have any issues with the bill. Thank you.
We appreciate the joke there, and thank you for your testimony.
Got a motion.
All right, we have a motion?
Move to report.
Okay, briefly, sir, we're ready to vote.
All right. Good afternoon. Thank you, Chair. My name is Gary Pan. I'm the Commissioner for the Department of Labor and Industry. Okay? And we all want what is safest for employees as well as employers, and we want to do what's right for business. But the new load stabilization system, it may be the safest and the best approach, okay? But this process and this proposal bypasses the current methodology in regards to how to accomplish this and get it into regulation, right? There are a number of different options. One being variance, okay, where an application by business that wants to use the technology is submitted to the DOLE, all right? The second area has to do with we need to demonstrate that it's safest for its employees, and its use would be allowed for all circumstances on that project. This is actually a quick way of doing it. Let me comment here that other companies would need to apply for variances if they want to use this technology, and that would also be a quick approval process. This would also lead to a regulation if there are a significant number of variances that are approved. So that's one area. I do want to clarify in regards to how VOSH's involvement is in this situation. VOSH could help potentially draft regulations, but ultimately these type of regulations would need to be approved by the Safety and Health Codes Board. All right, so just want to clarify that. Applications, a second methodology could be that petitions are submitted to the Safety and Health Codes Board. In this situation, applications would be submitted to the board by businesses or groups of businesses to amend the current standard to include load stabilization systems. This would take about, because of promulgation of the regulations, over a year, if not two. It may conform to the time period that the delegate is talking about. Ultimately, if this were to be submitted to the Safety and Health Codes Board, then it would potentially apply and be allowed for all businesses throughout the Commonwealth. So the DOLE actually opposes this bill as it's written and suggests these other options be considered. Thank you.
Thank you. Delegate Williams.
Mr. Chair, may I ask a question of Commissioner Pant?
Commissioner King.
Is this appropriate or not?
Yes, it is appropriate. Delegate Runyon.
Thank you. So I understand what you just said was that you opposed the bill as it written. Did that include the substitute that was just introduced that relates, that is it's a study to develop regulations over, I've forgotten what the period of time is, but wasn't it 2 years?
Right. So the way that we look at this is that we would rather industry make application for variance or petition as opposed to requiring DOLE to
Okay, so, and I apologize, Mr. Chair, if I may, apologize for skipping the part that I understood that variances are site-specific. Mm-hmm. So we would apply for a variance for the General Assembly building, and then we would need a separate variance applied when the crane moved across the street to the parking deck, and then a third variance for, that's not particularly business-friendly. So the variances are used for unique special circumstances, not for the industry day-to-day workflow. And so my intent when I agreed that I could support this bill was that it would go through the normal regulatory process. We were just asking the Commonwealth to do that. And that we would, my goal was to be permissive so that I could continue with the old technology, which is what my company uses, and have the opportunity for folks in certain circumstances to use this new technology if it were approved. So I'm somewhat confused with your all's opposition to the bill.
So in the delegate, in the situation that you outlined where we had multiple instances and project sites, the variance request from the first one would take some time, but because of the studies and the research on the first one, the subsequent ones would be faster, right? And as a result, if we had a significant number of these, then we could consider regulation on our own because of the weight of those.
Mr. Chair, follow up.
Dr. Run.
So again, not to be difficult, but a variance is actually, it should be for unique circumstances. It should not be for continuing business. And I think, to be frank about it, that puts a significant burden on the construction industry to apply for these, and it's not a particularly logical or rational thing. I don't mean to keep beating it. If perhaps that I should rescind my motion and that we would pass this bill by to have further discussions for personally, I thought we had peace in the valley, and so we apparently don't. So.
Thank you, Delegate Runyon. I think we have a substitute motion, or
Yes, sir. I would offer a substitute motion to pass by for the day.
Substitute motion to pass. We have a second. Favor the motion to pass by. Say aye. What's that?
So, Mr. Chairman, so the motion is to pass by.
Yep, we have a motion in front of us, sir.
Sorry.
Yep. We have a motion to pass by for the day.
Second.
All those in favor? Say
Aye.
Aye. All right, bill's passed by. Let's go check. Yep. Okay, right now we're gonna.
Sausage making.
Yeah, we are. But anyway, but that's okay. Well, it's more important that we get it right. Right now, I want to invite Delegate March is going by for the day on her bill, but I know some folks have driven a long ways to provide testimony to this committee. And so we're going to invite, so I think we have some members from Fire and EMS to provide some testimony related to House Bill 1813.
I'm sorry.
Yep. So for 1813, please step forward, state your names.
Good afternoon. My name is Glenn Dean. I'm representing myself on this piece of legislation. Beginning in 2008, there have been 11 attempts through the General Assembly to dilute the Code of Virginia and statewide fire prevention code to allow all manner of consumer fireworks in Virginia localities that have not adopted more restrictive provisions through the enforcement of the fire code. As you may recall, the fire code may be enforced at a local level, and based on the last survey I did in November 2015, 83.1% of the state's population residing in 37.9% of the state's land area have the services of a local fire official. The rest of the area is taken care of by the State Fire Marshal's Office. Within those local enforcement areas, 55.8% of the population residing within 10% of the state's land area have more restrictions on fireworks than the minimum set forth in the Code of Virginia and the statewide fire prevention code. This bill strips that authority away, which can be a dangerous precedent on many levels. While some may claim these figures are out of date, I can assure you with a high level of certainty that the margin of error is well within 3%. This bill also seeks to establish a law enforcement fund wherein money is obtained by imposing a 12% retail sale and use tax of fireworks, the proceeds of which would be, quote, used solely for the purposes of providing compensation to law enforcement officers in the Commonwealth, end quote. Law enforcement, which I take to mean police and sheriffs, excludes the fire service and EMS providers, which would be the most adversely affected segments of public safety under this bill. This is neither right and it is wholly unfair. While some law enforcement officers could be involved if there's a criminal act using fireworks, it is the state's fire service and EMS providers that would have to deal with the negative effects of fireworks use by the public through its responses to fires and or attending to injuries, and it is they that deserve supplemental compensation. It would be the local fire inspectors and fire marshals, not police officers or sheriffs, that would have to deal with ensuring the proper retail storage and sale and handling of these fireworks, and it is they that would deserve the supplemental compensation.
Excuse me, sir.
Yes.
Can you please sum up? We have several people behind you here, and yeah.
The only other thing that I had was there was no fiscal impact or revenue generation figures associated with the bill.
Thank you, sir. Appreciate it. Thank you. Hello.
Thank you, Mr. Chairman, members of the committee. My name is Bonnie Atwood. I'm the registered lobbyist for two fire organizations, the Virginia Fire Prevention Association and the State Firefighters Association. Both of those groups oppose this bill, as do 9 other groups, but I will let them speak for themselves. I do want to put on a personal hat just for a minute. I am the mother of a child with autism. I am a past president of the Autism Society of America Central Virginia chapter. And the autism groups have asked me to read a very brief statement. The Autism Societies of Central, Northern, and Tidewater, Virginia, along with the Virginia Autism Project, oppose the bill because people with autism are adversely impacted by sudden loud noises. Fireworks can trigger sensory over-responsivity, SOR, an extreme negative reaction to sensory stimuli. Obvious risks become apparent as an autistic child in a spell of panic produced by fireworks may leave his or her home, get lost, and even suffer a serious accident. For those reasons, I ask you to oppose the bill.
Thank you. Thank you for your testimony. Yes, sir. Welcome.
Hello, Mr. Chairman, members of the committee. Stephen Seitz, I'm the Assistant Fire Chief in the City of Fairfax. Also represent the Virginia Fire Prevention Association. In the essence of time, I won't repeat, but we agree with everything that's been said so far. I would certainly add to it another element of the bill that we are concerned about is that it removes all types of fireworks from when there's a person or persons that would manufacture, use these devices or have in their possession. Specifically, commercial grade fireworks are listed as can be exempted. And if it's used in a nefarious act, it's going to take away our ability to charge them under the criminal code. So that's another element of already what's been spoken to.
Thank you. I appreciate your testimony. Welcome.
Hello, Mr. Chairman. My name is Devin Cabot. I'm here representing the Virginia Fire Chiefs Association, and they, along with there's a total of 11 groups that come together to put together a legislative package for the fire services and EMS, and they have long-standing position to oppose the expanded use of fireworks in the Commonwealth. So we ask you to oppose the bill.
Thank you. Appreciate it. Yes, sir.
Good afternoon, Mr. Chair, members of the subcommittee. I'm Spencer Willett. I'm representing the Department of Fire Programs, and same beside me is Billy Hucks. He's the State Fire Marshal. So the Department of Fire Programs has some very strong concerns over the public safety aspects of this legislation and how it affects our ability, or I should say Billy's ability to do his job and maintain the safety of the Commonwealth, and also the localities that have their own fire marshals, their ability to maintain safety and make sure that we have safe fireworks shows and safe displays here in the Commonwealth.
Thank you.
Thank you for your time.
I appreciate that. Thank you. All righty. And I think right now we're waiting on Delegate Weber to show up here, but that will give me the opportunity to get to present my own bill. But I think somebody come here and sit, Will Moorfield, and I'll just go and vote on your machine. You can vote on mine. How about that? Well, let me get my bill here.
1930.
Thank you.
Yes.
Don't run off with my iPad.
Okay. House Bill 1934, Chairman Fowler.
Thank you, Mr. Chairman. This bill, basically what this bill does is it's very simple. It just requires any agency that estimates that a proposed regulation will have an adverse impact on economic growth or increase regulatory costs by more than $500,000 within 5 years of its implementation to advise the Joint Commission on Administrative Rules, the House Committee on Appropriations, and the Senate Committee on Finance and Appropriations no later than 30 days prior to the next regular legislative session. The bill requires the Joint Commission on Administrative Rules to review such regulation and issue a statement containing the Commission's findings and provide that no such regulation shall be effective if such regulation conflicts with any joint resolution expressing the sense of the General Assembly with respect thereto. And that's, of course, from the summary of the bill. And what the bill is intended to do is just to allow an opportunity for the General Assembly to stay kind of in the loop for regulations that have a big price tag, and of course several states, well, a lot of states have doing this. Some of them had a requirements as low as $250,000 and things even lower. So I did not, in this bill, I did not want to create such a low threshold just for a lot of reasons, but most notably, it would provide more work for the various committees to wade through all that stuff. So that's where I came upon the $500,000 figure. And so again, and this just provides a little more insight for the General Assembly who has to manage the purse strings to just be involved in this, in some regulatory oversight. And that's essentially simply what the bill does. And I would, if there's any questions, I'll do my best to answer them.
Okay, Delegate Adams.
Thank you, Mr. Chair. I guess my first question is, where did the 500K trigger point come from? I have a couple questions.
Yeah, well, that just came from, I just picked it out of thin air, basically, because what I found, Delegate Adams, is that it varies all over the country. And because of we're tying, having to require oversight, I didn't think it would be a good idea to set the threshold too low. And so again, but obviously, if people think that maybe the figure should perhaps be a little bit higher, I mean, I would certainly entertain an amendment.
Mr. Chair.
Yes, Delegate Adams.
So what it made me think about was that, at least the way I read it, it seems to take into effect, it seems to not take into effect the benefits, right? So like when you do a cost benefit analysis, you're looking at, okay, this is the cost, this is the benefit, is it worth the cost? And so it just seems one-sided this way because it's not really taking, if you make an investment and then you hope that the investment pays off through growth, and it just seems like it's not really taking in the whole picture, it's just sort of triggering this.
All right. Well, okay. Well, thank you, and I appreciate what you're saying. But by the same token, it would also be a little bit one-sided for the regulators or administrators, whatever we want to call them, to promulgate a regulation with a certain price tag on it and not have any oversight from folks who are actually elected by the people, I would say.
Mr. Chair?
Yes.
So do we have any precedent for something like this? Because 500K does seem kind of small. Is there any place else where we have some similar precedent that we could say, oh, it makes more sense that it's $1 million or?
Well, obviously not here, and I don't have all the paperwork in front of me, but it's this is going on in a number of states already. Yes.
Speaking to the bill.
Okay.
When it's appropriate.
Yes. So do we have any other questions from the committee members? Okay. Do we have anyone here to speak in favor or against the bill? Okay. Delegate Adams.
Thank you, Mr. Chair. And I guess my thought is I understand what you're trying to do completely, but if it's an arbitrary decision, might it be better to get an analysis for what would be appropriate, and then we could come back and make that regulation, maybe like a letter or something that would say what is reasonable or something like that?
Again, I appreciate the question, and I would just respond by saying it's the process which is the most important thing. The process is not arbitrary, but perhaps the figure is, and so again, if the committee would like to perhaps increase that number to another figure or whatever, I think, we could certainly entertain that.
Mr. Chairman, I may have a suggestion. I think that if we move forward on the bill today, that would give you enough time, and Delegate Adams an appropriate amount of time, I would think, to determine what that figure may be.
Mr. Chairman, I'd be glad to be more than willing and happy to work with Delegate Adams to come up with a more, a better figure.
Okay. Well, I'll entertain a motion.
Mr. Chairman, I move to report.
Okay, we have a motion to report with a second. Please vote.
Should I vote over there?
So we had a motion to report.
Mr. Chair, before we call a roll to vote, could I ask just?
Yes,
I'm going to vote no, just so I have a trigger for me. It doesn't mean that I totally want to work with you. Okay, thank you.
All right, the motion is to report the bill. members shall cast their vote on the machine here.
Three triggers.
Where's the thing at? Is this it?
That one.
It's got three triggers. That's like a triple barrel.
I tell you, I'm running all over the place here. We can close the roll. The bill reports 4-3. We can close the roll. Let me see if I can get a hold of Delegate Weber here. Anybody got a bugle? I'll ring that too.
Oh, we got it.
Here we go. Let me see. Delegate Weber, I believe you have a couple of bills in
have
front
two,
of us.
Mr. Chairman.
So
And
which one is your pleasure here?
If I could, I'd like to start off with 2347.
Okie dokie.
That would be the Department of Budget and Planning bill.
Okay.
If I could bring it up here.
Let's see if I can.
What this does, Mr. Chairman, essentially is it expanded a few years ago. We did House Bill 883, that was a regulatory reform pilot bill that we did with the Northam administration, with Secretary Lane when he was Secretary of Finance, in order to streamline and look at our regulatory system. What this bill does is it expands beyond that to the rest of the executive branch. But there's a couple of key differences. The differences in it, like when we did 883, was we set some standards at 25%. They had to get certain regulatory requirements. What this bill does is it allows a lot more leeway to the executive branch to look at that, but it also asks them to streamline things too, such as forms, et cetera, but also to look at regulatory requirements. And that's what the bill does, Mr. Chairman.
Thank you, Delegate Weber. Does any of the members have a question for the patron? Delegate Adams.
Thank you, Mr. Chair. My question is, I'm trying to understand the need for this. It looks like it codifies EO 19, but we already have a policy in the state that where regulations are reviewed every 4 years. And part of the reason that occurs is that there's public participation and transparency. And it seems like, if I'm interpreting this correctly, it's almost redundant. I mean, we already have a process of review. So I was curious about that as my first question.
So it sort of codifies, but it also what it does is it ensures that it's in our code that we continue to look at this and things get posted to the town hall for transparency as to streamlining this. Part of the reason we started with a pilot program and would like to expand this is that we did, in the 90s they did some similar things in regards to regulatory reform, say in British Columbia. They've done it in other areas where the public can continuously see and feedback via the town hall, and then with the person in place, another governor can't come along and just stop.
Any other questions from the committee?
Speaking of the bill when it's appropriate.
Okay, any questions from the audience? Any for or against the bill?
Mr. Chair, Ben Knotts with Americans for Prosperity. Just to give a little bit more context to what the delegate was saying, we worked with DPOR. I know y'all remember Mary Bros Vaughn, and so we found that what she discussed with us is that the pilot program was kind of, when they use like a 25% metric, you've basically boxed them in with regards to the innovation that they might want to address. So, for example, sometimes it might make sense to have more regulations, believe it or not, when you have a space that's basically a round peg and you're trying to shove it into a square hole. And so, like blockchain, for instance, right now we don't have a lot of laws for the blockchain. To streamline how they regulate that, it might make more sense to have more definitions and more regulations so that people can actually see where that is in the code. And so what the previous program had done was kind of just say arbitrarily 25%'s got to go, where they needed an outcome-oriented approach. So this bill was actually amended, or it was created with consultation of what was the best approach based on some of the feedback that we got from some of the bureaucrats that felt like we were just cutting regulations for no purpose. So this gives it a more outcome-oriented approach, and in some ways it kind of scales back the executive order because it's more outcome-oriented, if you will. And we support the bill, and we hope you will too, and appreciate your time.
Yes, sir.
Hi there, I'm Caleb Taylor. I have
Taylor Consulting. I actually worked on the development of this bill with Mary Braun and a number of economists who focus on regulatory burden, et cetera, and how to make that a lot easier. One of the things that Mary brought us, kind of pursuant to your question, Delegate Adams, was that the regulator, she flat out just said, there are a lot of regulatory requirements that the regulator doesn't actually have any say in because they're mandated in the law. And she mentioned that there wasn't actually even a mechanic for them to go and have that addressed. And that's part of what's in this bill is, we already have the 4-year we have the 4-year plan where the public can be involved. This allows legislators and regulators to work a lot more closely together, where the regulators can come and say, you have this mandate that is no longer necessary by our estimation. We needed to get addressed. Please help us do that. And I think that creates an opportunity for these regulators to be a lot more efficient in the way that they're doing things and the way they're building these things out. So we've got something for the public, we've got something for the regulator, we've got something where both of these groups can engage with the legislator in a much more healthy way. And I think that this will kind of help in that regard.
We thank you.
Mr. Chair, can I ask him a question?
Yes, Delegate Adams. Yes.
Thank you so much for your information. So what you're saying is that it doesn't eliminate the public participation and transparency of every 4 years, and that what it is doing is giving an opportunity for. Could you restate what it's?
Yeah, this isn't replacing that process at all. What this is doing is supplementing that process from a different perspective. That process was specifically designed for the public to be involved in that conversation. This process is specifically designed for the regulators to be more involved in that conversation. Because they themselves, when I sat down with Mary Braun and said, how did the pilot program work for you? She was very positive about the outcomes of the pilot program. I said, if you could change something about the pilot program to make it more effective, what would you do? Her number one thing is, I need to be able to talk to the legislators. I need to have some kind of mechanic by which I can go to a legislator and say, these mandates that we have right now are ineffective because the world has moved on. And they need to be adjusted in this way, or this is the estimated way that we would like it to be adjusted. What do you think? And so this program actually gives them that mechanic where they can go into the committee, directly into the committee, and just say, please help us with this. We're stuck, and this isn't helping. Yes.
Can I ask a follow-up, Mr. Chair?
Delegate Adams.
So are regulators prevented from participating now?
It's not so much that they're prevented. There's just not, from what I was told by the regulators, there's just not a mechanic by which that they can really engage in the process as much. They can come here and they can testify, but they come here and they testify on bills that are already made. They want to be able to come to the committee itself and propose to the committee, would one of you carry something that would fix these shortcomings in this particular regulatory or non-discretionary regulatory requirement?
Delegate Carr.
Thank you, Mr. Chairman. So they would read that, why can't they do that without having it written in code? I guess I don't understand.
Yeah, I understand too. That was exactly my question. Why can't you just go and talk to them? And the response was, yeah, we can go and talk to them, but we don't have like an official mechanic by which to do that, and we need that.
Delegate Carr.
It makes it easier for them to actually engage with the committee as an official body, with them being an official body. Right now, they can meet you in the hallway and have a conversation with you. But from what the regulators were telling us is we want to be able to have an official dialogue with the committees, with the whatever relevant committee there is, to address these situations. And we currently do not have a mechanic to do that. And so this is just.
All right. Thank you.
If I could,
Delegate Weber.
Mr. Chairman. Go ahead.
Delegate Weber.
May I?
Yep.
Thank you. Okay, so just real quick. Basically, it sets up a means where this is a continuous process rather than waiting for new secretaries or something else to be the mechanic in which we engage with some of these folks. And in subsection C of the bill, it identifies when an agency identifies these things, they will make that then report to the General Assembly, and then we can decide on whether those mandates need to still be involved or not. And so it's a continuous function of, I would say, almost a continuous function of customer service between us, the regulators, and our constituents. Does that make sense?
Yeah, what you're saying.
I think Don's still like, sorry, Delegate
I'm
Adams.
not sure that's necessary.
I apologize.
That's my feel.
Mr. Chair, may I?
Delegate Adams.
Thank you. I guess, to me, it just seems out of context with sort of normal operating procedure in that you have an executive branch. I know you're saying that's the point. I get that. But you have an executive branch who provides the leadership of the state. That's kind of their job. And then we make laws and influence some of that. But at the same time, when a new governor takes office, they oversee the direction of every agency branch. And so I'm not really following how this flows. So that's my issue. I'm going to research this some more, but today I'm going to end up voting no because I feel like I still have outstanding questions. Thank you.
Does any of the members have any other questions? Delegate Runyon.
Thank you, Mr. Chair. I would just like to comment that in my review of it, I thought we did a good job with it. And what I see that it does, it offers a nimble method to respond quickly to our constituents. And, that's the whole state organization. So I applaud the efforts of administration and the delegate to move forward. Would offer a motion at the appropriate time, Mr. Chair. Move to report.
We have a motion to report. We have a second. Second. The bill has been moved to report and seconded. Open up the roll. George. And close the roll. The bill reports out by a vote of 4-3.
Thank you, Mr. Chairman. Obviously, we have
some
some work to do with Delegate Carr and Delegate Adams and Delegate Jenkins.
Better get busy.
After I present the next bill, Mr. Chairman. Mr. Chairman, before you is 1758, which to some has affectionately been known as the Regulatory Sandbox Program. There are a couple of other states that have implemented this. Getting the policy right in emerging technological innovations is essential. A lack of regulatory clarity often hinders attracting cutting-edge industry. Too often, legislators like myself don't have sufficient evidence or proof needed to change a regulation. This is why other states have done so. West Virginia, North Carolina, Washington, D.C., Hawaii, Colorado, Utah have created regulatory relief sandbox programs of various levels. Getting the policy right in emerging technological innovations is essential. First, here's what they do. It creates an application process for a business to temporarily apply for regulatory relief, to offer a product and service that is clearly innovative in nature of the product or how the product is delivered. The application is processed by the Office of Planning and Budget, which will appoint a director who will coordinate with applicable agencies and the Joint Commission of Administration for administrative rules regarding whether the waivers are necessary and in the public interest. The applicant must provide sufficient protections for consumers who participate in the program, and the applicant must give regular reports on the progress of approved applicants. This bill's protections are equivalent to those required in other states with sandbox programs. The result of the program will demonstrate whether the regulatory code is sufficient as it stands or if it should be updated to accommodate the innovations in this specific market. In short, it ensures that we have a process informing us, the legislators, on what is happening in the market and how we need to update the code accordingly. While there are some here today who oppose the bill, basically the reason is, how many times have we brought legislation forward and revolved? So, for instance, Delegate Head is brought forward piece of legislation last year in regards to Bitcoin or cryptocurrency and things like that. So as we move forward, this is an opportunity for an emerging industry to do like basically a small pilot program, figure out what we need or whether it needs to move forward at all. And so that's what the bill does, Mr. Chairman.
Thank you, Delegate Weber. Do the members have a question for the patron? Delegate Adams.
That's what I'm here for, right? Thank you, Mr. Chair. So my question is really related to the broadness of the language and the potential implications because it's so broad. So my question is, if this is, as I've read about sandboxes and the origin of sandboxes, it's really about financial technology innovations. And so if that's the case, then it would just seem like, let's say that, because my concern is that you could also apply sort of this same legislation to public safety and public health, the environment. And so that's my concern with it, is that it doesn't specify financial technology and innovation. And if it did, I could totally see why that would be very helpful. But the broadness of it concerns me. Can you speak to that?
Well, I would say so for instance, there have been instances where we end up having to change the code to be flexible in emerging technology. So for instance, a couple of last year or the year before, Delegate Hodges carried a series of bills when it came to new technologies for stream bank erosion and things like that. And so I would say that the broadness is to encompass a number of other areas in which we can make improvements. Technology today is rapidly evolving, and so we need at least a system that is as flexible as our technology seems to be growing, and our economy.
Delegate Adams.
Thank you, Mr. Chair. Gosh, that thought just went right out of my head.
Okay, well, I have a thought, maybe.
I'm not going to.
No, I understand. Has that ever happened to you? Dang.
I mean, again, the way I read this bill, Delegate Weber, it just provides an opportunity for a new, innovative, some type of idea or product or something to get into. To get to the marketplace faster, basically. Is that kind of fair?
That is one aspect of this legislation.
All right, thank you.
It came back to me, Mr. Chair.
My thought. You ready? It came back to you. All right, very good.
She wrote it down real quick.
Yes, I would bring it.
I do that on a regular basis.
Thank you, Mr. Chair. My question is, in the current form, this is a new agency that's being created. Is that changed, or does that continue to be a new agency?
Oh, there's a substitute? There's a substitute, Mr. Chairman.
That's great, because I was getting ready to ask you that question, I think. But anyway, substitute, Ashley?
I apologize. There's a substitute.
Mr. Chairman, it's
I almost
posted
left mine out
online
on
now.
the
I think
bill
Delegate
over
Adams
here.
did that on purpose.
It's posted online now.
We have to adopt the substitute. Adopt the substitute of a motion.
Move to adopt.
Second? All right. All in favor say aye. Aye. All right, the substitute's before us. Since I can't see it yet, Delegate Weber, can you describe
If I
the
could,
substitute
I'll
for
phone a
us?
friend, because I think part of the reason that we brought the substitute is it eliminates the new department sort of aspect, which has a much bigger fiscal impact than the substitute before you. So that would change the structure a little bit. So I'll have somebody kind of describe how that changed.
Simply put, what we wanted to do was do what was modeled when Utah did it. We thought everybody would understand it better if we were just saying it was a department and it'd sound cool. So we just eliminated that and said we're going to house it in the Office of Planning and Budget, which is what when we talked to some regulators, they said that was probably the best place for it because that's one of their outcomes. And then we wanted to make sure that there was some legislative input, so we included JCAR in that conversation with the agencies, so that there was more input on when there was an application. So there will be hopefully a broad spread of excitement about what was being done, because that's clearly being innovation.
Excuse me, did you say JLARC?
Or JCAR, the Joint
Okay,
Commission.
gotcha. Okay, good, thank you.
Yes, Mr. Chairman, the Joint Commission on Rules.
Yeah.
I think it's done.
All right. Delegate
I
Weber.
apologize. Do you have a printed copy? I have not evolved in the sandbox realm where I...
It's been a while since you've been in the sandbox.
Thank you, Mr. Chairman.
Delegate Weber, does this bill, with the substitute, is there fiscal impact? I'm just curious.
I'm not sure what the physical impact is.
The Department of Planning Budget has funding set aside.
Do that? Okay. The Department of Budget and Planning has money set aside, so I believe it can be absorbed. So
Yep.
I'm not sure.
Yep, well, if they say
I'm
they
not
have
gonna,
it.
I'm not going to say yes or no, but
yeah,
I'm not sure.
If they
about
say
that.
they have the money, then that's good enough for me.
I'm not sure, Mr. Chairman. I know that there has not the physical impact. Part of the reason we did this was to change that, to make sure that there wasn't.
All right, do you want to offer some closing arguments? Delegate Weber?
Well, Mr. Chairman, as stated, I would just say that this other states have implemented sandbox programs, including our neighbor in West Virginia. I think Utah has a very good example of how this can be done in order to attract new businesses and at least provide a small semblance of regulatory flexibility in order for us to be able to regulate these new industries as they come forward and become part of our economy.
Very good, all right, thank you. We have, can I call the witness?
Oh, for sure.
I was going to say we have
Have you read the-
I'm gonna have to get you a call, sir.
Let me get this out of your way.
Hey, welcome.
Good evening, Mr. Chairman, members of the subcommittee. Emily Francis with the Southern Environmental Law Center. Thank you for the opportunity to provide some input. I want to thank the patron and his office for the conversations that we've been having today, so thank you very much for that. Our concerns should probably come as no surprise. We have concern over the wide open nature of the exemptions to state law and to state regulation that are possible in this program for up to 2.5 years. And of course, the potential risks and the impacts to public health and the environment is really what is central to the value of the concern that we have. So currently, as written and as amended in the substitute, we ask that you vote no, and we'll obviously continue talking with the patron at his office about the bill. Thank you.
All right, thank you. And Delegate Adams?
Yes, speaking to the bill, Mr. Chair.
Okay.
Sandbox, this idea of a sandbox is a really great idea when it's done well, and it turns out to be not such a great idea when it's done poorly. But again, my biggest concern remains that it is so broad in scope, and if it were really a safe space for financial technology innovation, that would make a lot of sense, and it would give us one very defined area in which to explore this. But because of the broad nature, I'm going to have to vote no today. But I really do think the sandbox structure is a good one when it's done well. And so I wish that it was more tailored. Thank you, Mr. Chairman.
Mr. Chairman, if I could, I have another
just,
person here to testify.
Some final testimony. Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Greg Leffel. I'm the executive director of the Virginia Blockchain Council. We're a nonprofit organization that focuses on innovative technologies like blockchain, digital ledger assets, and digital assets as well. We have members across the Commonwealth that are very interested in innovation. They're business owners, they're entrepreneurs, they're industry professionals that want to see innovation happen in a framework within Virginia, and we feel like this bill does that. We wholly support it, and we thank you for your attention.
Thank you. Yeah, Mr. Knox.
Americans for Prosperity, Ben Knotts. I did want to just give you a little bit of clarity too. We have sandboxes all across the country, and we have not had one approval of anything related to environmental. Like that's a huge thing. This bill is about technological innovation. And the reason we have this broad is because what's going to happen is you're going to have multiple industries that are going to come and say, hey, we need a sandbox here, which we've seen across the country. There was one for an agricultural sandbox because specifically they were barred from letting an AI controlled farming equipment because they had some regulation about how somebody had to drive one. So they needed regulatory relief there. So to save and when we were working with the Department of Health Professions, because last year we had a healthcare sandbox, they suggested there would be a director that integrated with all the agencies because some potential projects could have interagency, like EMTs, for example, if they were to try to do something, you have to deal with transportation, you have to deal with DMAS, you have to deal with the Department of Health Professions. So they said it would be better to have an agency that was, or somebody housed in the executive branch that would work as a director to integrate with these other agencies. And that was where the suggestion came from. And we are happy to look at some improvements to the language to address those concerns, because this is about innovation and making sure Virginia is the home for innovators. And that's what we're trying to get to.
Thank you. And you wrap up.
Mr. Chairman, if I may also, the previous witness, I think the witnesses explained why this is a good piece of legislation moving forward. But however, I will clarify on the budget. We submitted a budget. There will be. It will need a budget amendment. We put in a budget amendment for the previous before the substitute. So the budget amendment that was proposed is actually more than what the substitute's going to cost. So unfortunately, if approved, we'll have to go upstairs.
Okay. All right, so
so that we're clear.
I think we need a motion.
Move to report.
And refer.
Report and refer?
Yeah.
Okay, is there a second? Second. We have a motion to report and refer. All those in favor of the motion can express it on the electronic voting machine. All right, now we close the roll. And the vote is, the bill is reported 4-3. And
thank you, Mr. Chairman, and thank you all for waiting for me to get over here. I appreciate
you're
it.
welcome, but it's
Whoever's going to cost you goes. That's a private
Come to my office.
I want to thank our clerk and our staff for hanging in there with us. And you know, as we get a little bit further along, I think it'll probably get better. So thank you. We get these bills done. Delegate Adams, I want you to get with. Yep. We're adjourned.